something new design. This is the example of technology. Invention makes our lives safer. Garrett A. Morgan has given the signal system. He thought on that when when he saw a terrible accident between horse carriage and the car. He thought, how can I prevent further such type of accident? And he has given solution that's a signal system which you are following in each city of the country or worldwide. New designs. Again, this is the new design developed by one of the student, National Institute of Design, Ahmedabad. Every students during the degrees or PGs, they have to do the project to get an award degree. So he was the student of National Institute of Design. So he thought something he should do. So he went to the construction company. He talked with many coolies. Are you facing any problems that you are carrying stones, bricks, sand, cement on your head? They told that they're having neurological disorders, back pain, disc pain. To overcome that, he has brought this device, which is new. We can say carefully, it is not touching the head. It is above the head. Most of the weight is on shoulder. Distribution of weights, again physics formula. And he has given solution to a technical problem. That's a new design. Why can't you and me think and give the new design? There are many products. Another kind of intellectual property called semiconductor integrated circuit layout design. SICs are fabricated from a complex series of layers of semiconductors, metals, and dielectrics. These should be original, distinctive, capable of being distinguishable from any other layout design, and have not been commercially exploited anywhere else. Then that's called as a design. The term of this is 10 years from the date of application of filing or first commercial exploitation, whichever is earlier. Another kind of intellectual property called trademark or branding. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the good, distinguish from the goods of the others. It's called authenticity of goods. Reliance, Tata, Bata. This advertises goods and services, protect the innocent public from buying the goods of second-hand quality. We know many products in the market. We don't know exact name of that. What is the name of the fonts and spelling? POND apostrophe S. Somebody brings only POUNDS. It's a second-rate quality product, but we don't know name of that. We directly buy that it's an original, but then second-rate quality. R with encircled is a registered trademark. TM means they have applied for it yet to get the rest. You can see in many products, some are R encircled, some are TM. Duration is 10 years. It can be renewed every 10 years, subject to the usage. There are different trademarks like collective mark, certification marks, taglines, slogans, and shapes. Another kind of intellectual property called geographical indication. Place names used to identify source of origin, quality, reputation, or other kinds of products like Darjeeling tea, Kanchipuram silk sari, Makrana marble of Rajasthan, Ratlami se of Madhya Pradesh, Katputli of Rajasthan, Bagh prints of Madhya Pradesh. Many more are there. Even if you check agricultural products like Magai Pan, Devanelli Pomelo, Apimidi mango, Kashmiri saffron, Sailicha Bihar, Kurg oranges. If you check in food products, Rasgulla of Bengal and Odia, Tirupati Laddu, there are many perfect out there. Let us see another kind of intellectual property called copyright. Copyright provides holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, and software also. The term of protection is life of the author plus 60 years. Therefore, you might have heard many singers sung the song. They are no more, but still they are getting the royalty for that. Many authors of the books which you are referring may not be there, but still they are getting the royalty for that. If you are writing books, novels, stories, autobiography, poem, or any literary work, it comes under Section 2 of the Copyright Act. If you're doing artistic work under Section 2C of the Act. If you're doing dramatic works under Section 2H. Musical works under Section 2P. Sound recordings under Section 2XX. Cinematographic films under Section 2. So each kind of work is, you can go for the registration. Again, different IPs in single product. I have taken Apple as a laptop. You can see the signal, this Apple signature is a trademark Apple. How it displays, it's a technology. You can get patent for that. Body of laptop is a design. Which kind of design? The manual which you are using for operate, that's an user manual, you can get copyrights. The circuit which are there inside is an semiconductor integrated circuit layout design. So that single product, you can product with the patent, design, trademark. Therefore, Apple company never copy the technology of Samsung, Reliance, or any other company. Like mobiles also. You can check Apple mobile, Samsung, Reliance, Vivo, Apple, Oppo. Vivo cannot copy the technology of Oppo or Apple. Apple cannot copy the technology of Nokia or Samsung because each got protection of patents, designs, trademark. Therefore, independently they are playing in the market. No one will be the competitor for that. So if you are developing any technology, please protect, then come in the market so that no one can copy your technology. No one will be the competitor for you. What are the career opportunities for the students in the IPR? If you are MS in chemistry, biotechnology, microbiology, physics, or any branch of engineering being, then you can become examiner of patents and designs in the government of India. Depend upon the vacancy and advertisement. You can apply for that. There are two papers. First is objective, another is descriptive. If you qualify, you'll get a job in the government of India. If you're having law graduation, you can become examiner of trademark and GI or examiner of copyright also. Others, if you're having knowledge of IPR, you can become patent agent. Any science graduate, BSc, BCA, CBZ, any branch, any science graduate can become patent agent. Again, there are two papers. One is objective, another descriptive. If you qualify YOC, then you will get in. Then again, final qualify, you get a patent agent number from the government of India. You can practice it, or you can have one firm, or wherever you want, you can join in the JRF, SRF, or any patent litigation centers. Also, if you're having knowledge of IPR, or you can work in the IPR cell of central government, state government, MNC, or any company, or IPR policy making also. Or you can work in the NGOs who are making facilitation between inventor to the government of India. Or you can work in the IPR firms. There are big IPR firms in Chennai, Bengaluru, Mysuru, Mumbai. They live in big cities, Pune. You can join there. You can work as a patent litigations or patent drafting or patent replying for the letters. Whatever you want, if you're having knowledge of it, you can work. Even you are scientist, you might have awarded many PhDs, many students might have worked under you, but you are not an inventor. If you want to inventor, by simple approach, you can become. While carrying out research in BSc, MSc, or any branch of B or any project, identify some problems in and around you. Solve that problem, definitely you can get the patent for that. For example, there are many mosquito catching devices in the public or in the market, but I am being a computer science fellow or being computer, I want to develop digital mosquito catching device. New invention. Digital means it is observing, it is giving shock to mosquito, but not to my hand. It is recognizes human hand. It's a digital. Or I am bringing new a process of preparation of beverages from food and food products. New process. Or if you're bringing a new modified mobile having so and so features, again, same product. Or process of preparing medicine, if it is new, again that. Apply for that. Process of preparing alcohol, process of preparing biodiesel from my campus waste. Many topics at touch. Or SMS alerts a farmer when wild animals are entering his field. Again, signal-based system which we can give SMS alert to a farmer. What is patentable India? All the inventions which are new, novel, and having inventive stuff, they are capable to get the patent in India. When we can say your topic is new, when it should not be published in India or elsewhere throughout the world, we check for the novelty. Again, it should not be the prior public knowledge or prior public use within India, or should not be claimed before in any specification in India or elsewhere. Then definitely your invention is new. You can file the patent application. Under criteria, we should qualify the definition of inventive step also. Before that, what is inventive step? A feature of invention that involves technical advancement as compared to the existing knowledge. As I told you, existing knowledge is an telephone, advancement is an mobile. You can check AG Bell telephone to mobile. What is this? Technical advancement or having economic significance. Earlier, simple Nokia mobile in the year 2000 was more than 5,000 rupees. Now, 500,000, 2,000. What is this? Economic significance. Or both. That makes invention not obvious to a person skill in that. What is obviousness? Making dosa is very obvious. Making curd rice is very obvious. But to get in patent, it should not be obvious. It should require some experimental skills to get an invention. And who is the person skill in that? For example, my invention is a pharmaceutical drug, then any pharma fellow is a person skill in that. If my invention is a herbal medicine, any botany, biotech fellow is a person skill in that. If my invention is a device which convert sugar molasses into alcohol, any mechanical engineer is a person skill in that. So it should not look obvious to them, but definitely you are qualifying the definition of inventive step. Like surprising result if you are giving, solution to a long-standing problem you are giving, fulfillment of a long-felt need, or a great technical progress if you are doing, definitely can go further. Right. Invention should be capable of being made or used in the industry. What are the, if you are developing invention, what are the content of that? It should have title and preamble, like process of preparing herbal medicine for cancer. Object, allopathic treatment or chemotherapy is very side effect, so I'm giving herbal treatment. What is there in the prior art or literature survey? What efforts you are putting to bring the solution for that? Detailed summary of that, statement of the invention, detailed description, examples, then claims you have to claim, then definitely are getting patent for that. This is the way of writing the patent application. Content of the complete application should be in this fashion. Now, you learned what is patent, design, trademark, copyright, and semiconductor integrated circuit law. Now, how to file the patent application in India and who can file? Any person, startup, MSME, anyone can file the patent application. There is no age bar limit nor education limit to file the patent application. Physically, you can file by going to your jurisdiction. As you are from South, you can go to the Chennai office, or we have given facility to file online. You can file online since July 20. We have given the facility. Different jurisdictions, yeah, Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and Union Territories of Pondicherry and Lakshadweep. Newly formed state Telangana also. What are the documents required for patent filing? Covering letter indicating the list of documents in that form 1. All details of the applicant, email address, contact address, everything should be given. What type of the application you are filing? In that, proof of right means inventor who are helping out the carry out the research, they have to sign in the form 1. Again, proof of rights is required for that. Whether you are filing provisional means as soon as idea comes to your mind, you are filing, that is called provisional. Once you are completing whole your research and you are filing with the claims, that is called complete application, that is on form 2. If you are filing foreign filing also, then you can give form 3, which country you are filing, what is status of that. Form 5 is required to add your friend's name. For example, I am from biotech department. I have done invention for medicine. Then I'm adding my microbiology friend name, chemistry name, you can add. But think that once you're adding their name, once your product is commercialized, you have to share equal benefit to these people. Therefore, think and add your friend's name. Form 18 is for the request for examination. Until unless you request, we never examine the application. Drawings, if any. Abstract of invention is form of check or DD. Request for early publication is form 9. If you are going through agent, form 26 requires, that is power of attorney. Fees for individual is 1,600. For the company, it is 8,000 up to 30 pages. Per page, you can check the fees. RS 160 for individual, 800 for the company for the patent specification. For the claims, 320 for individual, RS 1,600 for other than that. 80% fee for teaching institutions. So you are also from college, you can take the benefit of that and you can file more and more patent application in India. Even you can request for the examination fees 4,000 for individual, 20,000 for company. Form 9 is not compulsory. If you want early publication, you have to pay extra fee. You can go for the publication. Even you are having chance to file the expedite examination as per Rule 24B. Form 18 is a must for that. Who can file? The person who is choosing PCT application. In that, if they're choosing India as an international searching authority, means who can search the topic and say it's novel, or International Preliminary Examination Authority who can give the examination report on that, or applicant is a startup, or as per 2019 rule, one of the applicant ladies in your group or government organization or institute can also request for that. Fees for Form 18 is 8,000 for individual, 60,000 for the others. Again, you can check our website here. If you go to patents, you can click all in it comes patent filing. Designs, trademark, GI. If you want to file online, you should have e-signature or digital, go for comprehensive e-filing. If you want public search, then go for here. You can put your queries like herbal composition for cancer, a device mosquito catching, a device for protection. So whatever title you can put and search if it is new or not. You'll come to know. If it is new, you can go for the patent file. Now we are granting the patents in India. Once you are filing the patent application in India, it's go for the digitization, screening, and classify which subject, mechanical, electrical, physics, civil, which branch it is. If you are requesting for early publication, we publish within a week or a month. Otherwise, 18-month publication for that. Once it publishes, anyone can oppose. That's called pre-grant opposition. By anyone can oppose. If you're filing request for examination within 48 months, it's go to the allotment to the examiner and control. They examine the case, they bring the list of documents of formal and technical, prepare the report that's called first examination report, forward to the control. Again, he examines. If you want to add, he can do final correction and give the report that's called first examination report. You have to reply within 6 months. If you are unable to reply, you can take the extension of 3 months. Within 9 months by hook or crook, you have to reply for that. If reply is okay, good, then you will get a patent certificate. If reply is not to get okay, you will get an opportunity of hearing. Means second letter will come, you can come to office or online video calling facility. Just join, solve the queries of controller or make us understand that it's new and novel. If it is really approving, definitely it will be granted. It is patent granted. And once it's granted, it's go for the publication that is called post-grant publication. Within 1 year from the date of publication, any interested person can oppose. Starting, I told you, anyone can oppose, but after the grant, only interested person. Now, who is the person interested? For example, Maruti Suzuki developing some new engine, then Hyundai company, Tata Motors, Mahindra, Suzuki, anyone can oppose that because they are involved in the same business. They are called as person interested. Again, once the opposition comes, we consider an opposition board inside the office. There will be recommendation on the board, and we consider that during the hearing. If applicant able to overcome all the grounds of opponent, definitely be granted. If applicant fails to overcome the ground of opponent, it will be rejected. If you're granting or rejecting, we give the speaking order so that you can appeal in the higher courts. Now, how to file design application if you're developing new design of any kind? Here, you should file Form 1 as per Section 544 Rule 11. In that, if you are a natural person, 1,000 rupees fees. Other than that, as a small entity, 1,000. Startup, 1,000. Other than that, 4,000 fees for filing the design application. Form 1 with the name of the applicant in full, nationality, legal status, address for service, which class your article is, prior data if any, prior registration, signature of that should be given. 2 set of presentation you have to prepare with the drawings, power of attorney if you are going through agent or lawyer, priority document if you are having, assignment if you are having, form 2 if the applicant is startup or MSME is required for the design filing. We are using Locarno classification of the design, that is 32 classes, 237 subclasses. For example, You are developing new design as a medical device, as in BP measuring machine, class 24. If you are developing something, pharmaceutical products like an Fair and Lovely, it's in class 28. Machines, class 31. So depend upon your design, which class it is we have to classify. But to prepare the sheets of 1 or 2 pages by writing how your product is now. I'm claiming here is an teapot. You can put your name of the college as an applicant. Total number of seat 8, 1 of 8, 2 of 8, like that you have to put in full, but here in the detail. And novelty resides in the shape and convention, how it is new, you have to mention in 1 or 2 lines. Signature and the application. If it really looks new, it can go for the register in the Design Act. Again, these are the bad quality of the design. What is the role of patent system? Encouragement or improvement of technology. AG Bell was there. Now we got mobile phone, video calling facility, Google Meet. What is this? Improvement of technology. Providing reward as an exclusive right for disclosure. Means you're doing something new like herbal shampoo, new device. Then government is giving you right. It's patent right. Making profit or earning royalty through putting the invention practice. Means first practice the invention. If it is new novel, get the royalty out of that. Transferring it to public property after expiry of term or once premises. After 20 years only, it will directly go to the government's hand. Or you got the patent but unable to pay the renewal fee, it will be seized, then anyone can use your patent application. Again, what to do now? You came to know about the different intellectual property rights. Therefore, don't wait. Share the benefit of patent system in school, colleges, universities, where you want to. Utilize the resource through organized R&D activities. Capture the global market judicially, means legally. Protect first if you are doing something new, design, patent, whatever may be, then go for the market. No one can copy and make the benefit of that. Thank you. Now, session is open for the discussion.
Thank you so much, Dr. Suryavanshi sir. It was really a wonderful session on the various aspects of the IPR, patent, and design filing. And thank you so much for your session. And I welcome students if you have any questions, queries, or any comments on IPR and patents. Thank you so much. If you have any queries, please raise your hands.
You can share the feedback link in the chat box so that they will fill. Any question, dear participants?
Students, you may ask the questions, please. If you have any queries, you may directly ask sir, or you can even message in the chat box if you have any questions.
Yes,
you
no
can
problem.
leave a message in the chat box so that you can directly contact you. Sir, can you hear me, sir?
Yes.
Yeah, just for the time being, I have just a small query. Actually, do we have any global consensus on the legal formalities on the patents and the IPR? So each and every country has their own separate laws regarding IPR and patents. So if each and every country has their own separate laws, then how we can get into a consensus on a particular debate or one issue is raised or a patent or IPR? Thank you, sir.
See, as you know, every country is having IPR law. For example, somebody is developing software as such. In India, we are not giving patent for that. So directly you can take the permission. You can file in the US, you can get software as and patent. But in India, it comes from the copyright. So depend upon your work, which type of that, which country are eligible, you can take the permission under section 39 of the Patent Act, you can apply for that. Even method of treatment, we are not giving India, but US is giving patent for that. Even planned as such, we are not. Freelance patent, we are not. Many things are there. Country to countries differ. So depend, if you want to file your patent application, you should know whether your subject matter, what you're involved, what is inventive, whether it is qualifying in those country or not, then only you can eligible for that. If you're developing a device which is having combination of software, hardware, even India is get patent, USA, Japan, even European countries also you can get the patent for that. So every country is having law, you have to follow that and you file the IPR depend upon the country.
Thank you, sir. Thank you so much. Students, is there any queries? No.
Take one pick for the students, take one pick of your seminar and you can give me in the email so that we can give in the reports.
Now I invite Dr. Anju here, the coordinator of IPC Human College, to offer a formal vote of thanks.
Respected chief guest of today's function, Dr. Bharat N. Suryavamshi, respected principal, vice principal, my dear colleagues and dear students. Today we had a very informative talk on intellectual property rights from a very apt person who is the Assistant Controller of Patents and Designs at Rajiv Gandhi National Institute of Intellectual Property Management, Government of India at Nagpur. It was a great pleasure to have a person of eminence like Dr. Bharat Suryavamshi with us to enlighten our students on the concept of IPR and patenting. And I hope our students might have got an idea about what exactly is property right, copyrights and trademarks from this talk. We express our wholehearted gratitude to Dr. Bharat and Suryavamshi for being with us for today's program, spending his 1 hour, quality 1 hour with our students, even in the midst of his busy schedule. So thank you very much, sir, for being with us. On behalf of Newman College, Thodupuzha, I extend our wholehearted thanks to you. Thank you, sir. And I also extend our gratitude to National IP Awareness Mission. The mission have been associating with us from the previous years. Also, last year also, we got the opportunity to conduct a program in IP under the IPR cell of our college. And this year also, we got the opportunity. So I'm very happy to express our gratitude to the National IP Awareness Mission and the initiatives of Government of India in promoting intellectual property as a whole. So our gratitude to the IP Awareness Mission, and also we extend our wholehearted gratitude to the management of Rajiv Gandhi National Institute of Intellectual Property Management, who was associated with us in conducting this program. In addition to this program was organized under the umbrella of Institutional Innovation Council and IPR cell of Newman College. I express my gratitude to the convener of the Council, Dr. Subin Jose, and President Dr. Bijoy Thomas, and also the coordinator of our IPR cell, Dr. Krishna Kumar, sir, for conducting such a wonderful program for the students. And I also extend my wholehearted gratitude to Dr. Jitin Joy, who has been assisting with us for the smooth conduct of the program. And my sincere gratitude to IQAC staff, Nitin Jose, who is live streaming the program right now. And also to the non-teaching staffs, Matthews, and all the other non-teaching staff who has been helping us in live streaming the program, and also to conducting all the giving us all the technical assistance. Last but not the least, I extend my thanks to all the students who are present here. And of course, my thanks also goes to the program coordinator of this program. Along with Krishna Kumar sir, we have Dr. Anu Mary Joseph also as the program coordinator of the program. But today, since she is acting as an external examiner in another college, she could not present here for the program. I extend my wholehearted thanks to Anu Miss also for putting the efforts to make this happen here, and also to the entire management, principal, vice principal, Barsar, and the entire management for supporting us in all our endeavors. Thank you, Mananjo. Thank you, and have a nice day.